this is Janet Rivera again. Today, I will discuss to you about what is the concept of the Republic Act 4726, or what we call the Condominium Law of the Philippines. The Republic Act 4726, as you have noticed, is an act to define and establish requirements for its creation and govern its incidents. So, in this video, I will discuss to you the appropriate things that you need to know about condominium. In the short title, we call it the Condominium Act of the Philippines. The condominium is an interest over a property consisting of a residential, industrial, or commercial building and an undivided interest in common, directly or indirectly, in the land of which it's located and in other common areas of the building. A condominium may include an addition, a separate interest, and other portions of such real property. Title to the common areas, including the land or the apportionment interest in such areas, may be held by a corporation. Take note, ha? This is by specially formed to purpose hereinafter known as the Condominium Corporation. So this is what I'm telling you on my first video, that a condominium is governed by corporation laws, in which the holders of separate interest shall automatically be members or shareholders. So they automatic, you are a stockholder. So to the exclusion of others in proportion to the appurtenant interest of the respective units in the common area. The real right, your property right in a condominium, may be ownership or any other interest in real property recognized by law on the property in the civil code and other pertinent laws of the Philippines. So this is a complex thing, you know. The condominium law is still governed by the real estate law of the Philippines as a whole. So we will define what is condominium. Condominium means A, it is a unit for independent use of one owner, including one or more rooms or spaces located in one or more floors in a building or buildings and such accessories as may be appended thereto. C, a project. What is project? Means the entire parcel of real property divided or to be divided in condominiums. Let's say it's still whole. I'm a developer. I'm preparing to develop 2 hectares of a property to become a condominium project. Another thing is common areas. Means the entire project excepting all units separately granted or held or reserved. And D, to divide. Real property means to divide the ownership thereof or other interest therein by conveying one or more condominiums therein, but less than the whole thereof. So what do you mean to divide? Mean to say individual rights on the building. But of common interest, like the open spaces, the parking lots, is of course for the whole shareholders. The Section 4 of Republic Act 4726, or the provisions of this act, shall apply to a property to be divided already into condominiums only if there shall be recorded in the Register of Deeds. In the Register of Deeds, there is what we call the master deed of title. So, number 1, description of the land or the buildings is attached to the master deed. The survey, of course. The certificate of the registered owner of the property, if he is other than those executing the master deed, must a special power of attorney. And then a diagrammatic floor plan of the buildings in sufficient detail to identify each unit, its relative location, and approximate dimension. So when you notice, when you buy a condominium, it is not exactly the same. My clients usually have 32.6, 32.8 meters, 32. Yes, that's it. So you notice that in a parking lot, we let buyers sign the deed of assignment of of common areas. We call it the do the DA DA the deed of assignment contract, so that each clients will adhere to the restrictions of the whole condominium project. So we call it the deed of restrictions. Any transfer, if you want to transfer your condominium, this is for you, section 5 of 4726. Any transfer or conveyance of unit or an apartment or space shall include the transfer of conveyance of undivided interest in common areas. In the proper case, the membership of shareholdings in the condominium thereof, provided that where the common areas are owned by the owners of separate units, co-owners. So this means, in the section 5 of 4726, this explained is, you sell only the unit you have, not the common areas. So it is different. So when you ask, somebody asked about, one of my clients asked to me about, can I use the parking lot at the clubhouse? Of course, no. We have assignment of parking lot in each building, so you don't need to use the parking lot. You can use the parking lot only if the guard allows you, or if you drop somebody on the clubhouse and then you go pick and just deliver somebody there. That's allowed in our condominium project. So what other things, there are questions on my clients that they're asking, that how about if I sell my unit and it's still not yet paid? It is still amortized in the bank. Can I transfer it to my name? No. The answer is no. You still need to pay on the bank of the balance of the one you, of the one who, where you purchase your unit. You still pay in her name. So if you want, you can build a contract attaching to your contract of sale that you are going to purchase, and the owner of the unit that you are buying must execute affidavit of undertaking that she is willing or he is willing to execute a deed of absolute sale when you have completed the payment in the bank. And you have also to know that the client, if somebody dies, let's say your client dies, the buyer the seller dies in the middle, halfway of the 10 years contract of amortization on the bank. This is again another problem for condominium unit owners, condominium buyers. You have to take care of the insurance policy will go directly to the family. So what I advise you is, you have to let the family sign a waiver if in case that all the insurance shall be paid. When the bank is paid, the title will surely be delivered to the heirs. That's automatic in the Philippine law. When somebody dies, the inheritor will be automatic the children. If there's no children, we call it ascendant. We go higher up, auntie, uncles, grandmothers, grandparents. That's how it is in the Philippines. So you have to let your seller sign that the children will waive all the rights to the property once once the seller dies. Because paano mo mahabol yung pera mo doon if nobody will, you have no attached papers on what you're doing. So in our company, Philinvestland, once somebody assumes a unit or a condominium unit, the assumption is not allowed in the operations. You have to do it internally within yourselves, because it is not allowed under Philippine laws that you purchase the unit while you're still paying it in Philinvest, the down payment. There's nothing like that. And also, once the down payment is paid, the title is in the name of the seller, and you are buying you are a buyer, that you will buy the condominium unit during the takeout period, or when the approval of loan is already there in the name of the seller. Now here comes the problem. Can you assume it on the bank? Not unless you apply for a separate loan. Not unless you redocument everything. So this, we call it the redocumentations of the purchase. So you have to change everything, the name and everything. But we can do that. But if you can do the hustle and the bustle of doing that process, then good luck to you. So I advise for buyers to purchase your own unit. You buy it for yourself and you pay it in full before you sell it. That's my advice to condominium buyers, because there is no problem when you do that. There is no hassle when you do that. So it will only take around 3 to 6 months to process the transfer. Once Philinvest deliver the title to you because you paid it in cash, within 6 months, you can transfer it within a month's time. So, again, by the next video, I will explain to you the corporation law, because condominiums is governed by corporation law. That's why there's a 50 years time frame always questioned to me by my clients. What is this 50 years? Does the condominium loses its value after 50 years? The land does not lose the value. It appreciates by a thousand percentage. But the building depreciate. So your next question must be, in 10 years, does the building has its value? No. In 10 years, the building has zero value. So during that time, the 10 years time, the homeowners association will have a meeting of whether it will be on votation, because it is a stockholders meeting, if whether they will restructure the building, they will pay for the whole restructuring of the building. They will, syempre, they will ask for something else, that would like to make a loan on the bank again. So within the 5 years period, it still has a value and the land appreciates. So if you have any questions, drop your comment below. I am always ready to answer your questions with regards to real estate. And in the manner of reconstruction, once you purchased a building and then a unit, and then it's turned over already to you, and you started to change the building itself, the unit itself, you have to move the room to the other side. You have to pay the bond to the developer. That if when you restructure the unit, it does not affect other units. So that's why there's a bond you have to pay. This is all matters of condominium that we're discussing, and I hope that you enjoy watching my video, and I hope that you subscribe on my channel. Thank you very much and have a nice day.